All right. Hi, everyone. My name is Danielle. I'm just setting up the tech side of things. So, Mike, you're ready. Take it away.
All right. Well, thanks, Danielle. And first of all, Danielle, thank you so much for doing everything that you are doing today. This is quite the heavy load, but we got some pretty cool stuff coming out on our Hazelwood Day of Action. Well, first of all, let me just introduce myself. My name is Mike Heaston. I am the senior legal consultant for the Student Press Law Center, and this is kind of our kickoff for what we're calling the Hazelwood Day of Action. 30 years ago, this month, the Supreme Court announced its decision in Hazelwood versus Kohlmeyer, a decision that drastically altered the balance between students and administrators in terms of what sort of First Amendment protection they have. We're going to talk a lot about that today. But in addition to our conversation, we also have lots and lots of stuff going on over on our Facebook page. We have speakers at the top of every hour kind of giving their perspective on what Hazelwood is and what it means today. We've got newsrooms across the country writing op-eds about Hazelwood and using our Cure Hazelwood, hashtag Cure Hazelwood, to get those stories out. And we also encourage you to, at any time, visit our website at www.splc to find out more about Hazelwood and some of the things that you can do to correct this decision and to protect student journalists from censorship. Well, I am absolutely thrilled this morning, it's morning where I am at least, to have with us the two people who, like I said, Hazelwood was handed down 30 years, and we are joined this morning by the folks that were pretty much at the helm of protecting student journalists during that entire 30-year period. I have with us the executive directors from the Student Press Law Center, starting with Mark Goodman, who was the Student Press Law Center ED from 1985 to 2007. Isn't that right?
Correct. Yeah.
And is currently the Knight Chair of Scholastic Journalism and a professor at Kent State University. And we also have with us Frank Lamani, who is the most recent executive director. He was with us from 2008 until just a couple months ago. And Frank is currently the director at the Breckner Center down at the University of Florida. So thank you guys both for being here.
Yeah, thank you, Mike.
Yeah. Very cool. Well, Mark, I think, one of the things I love telling the story about how the year that I started at the SPLC as a legal intern, the summer of 1989, so it was the summer after Hazelwood came down. I love telling the story about how when people, needed to contact us back then, the only way they could really do so at the time was snail mail. And if the issue was
telephone, that old-fashioned telephone.
But they had to pay for the call, right? So it had to be super urgent in order to get in touch with us. But I think it's important to kind of set that stage because in 1988 and before, I guess, when the things were happening in this Hazelwood case, it was a different time. I mean, there was no internet. There was you didn't have cell phones. The student newspaper was, for many students, it was their single forum. That was the place that they could express their viewpoints. So, I'd like to start, Mark, perhaps by your telling the Hazelwood story from the SPLC's perspective. I know the story began in 1982, 83 school year. You were in law school at the time.
I was but a child, yes.
But a child. And you joined, I guess, in 1985. So, I mean, perhaps you can kind of give those unfamiliar with the case a brief summary of what the case was about and how Hazelwood or how the SPLC approached it at the time.
You bet. Well, it's worth remembering, first of all, I think, how different, as you've already alluded to, how different the law was then. I mean, at that point, we operated under the presumption that the Tinker ruling from 1969 was the legal standard that applied to all acts of censorship at a public school. That essentially, if a school wanted to censor student media or any other kinds of student expression, it had to be able to show that there would be some material and substantial disruption of school environment if they didn't censor, or an invasion of the rights of others. And that was a pretty high hurdle, for school officials to overcome. And this was based on certainly the Supreme Court's decision in the Tinker case, but also a number of lower court decisions that have been decided over the years. But, we were pretty strong in our confidence that that was the legal standard that applied to all acts of censorship. So when the Hazelwood case came along and ultimately, as we'll talk about in a minute, changed that, it really pulled the rug out from a lot of us. But how the Hazelwood case began, as you noted, 1983, in May of 83, these students at Hazelwood East High School outside St. Louis, Missouri, were producing a spread of stories for their student publication that covered issues that were relevant to them. And I think I have a picture I can show here of it. See if I've got the ability to actually make that happen. So if you can see right now, and this is admittedly much reduced, so what they did was prepare the spread of stories about the problems teenagers face, some of the problems teenagers face. And these are stories that are really evergreen. I mean, I think about how these stories could appear today in a high school newspaper and not seem the least bit out of place. And this was 30 years ago, but it was a story about teen pregnancy, about teen marriage, juveniles and, juvenile delinquents and runaways, and divorce. And specifically, what two stories on this spread ended up being objectionable to the principal at the school. The story about teen pregnancy, which it did include the personal accounts of 3 students at the school who either were pregnant or had recently had a child, and the story about divorce, in which students talked about their experiences with having divorce in their families. And at the time, I remember the school principal objected to these stories for a complicated set of reasons, removed the 2-page spread from the newspaper while it was at the printer, had the advisor remove it from the paper while it was at the printer. The students first learned about this censorship when the paper came back from the printer and it was shorter than when they'd sent it, and they thought the printer had messed up. They had no idea they had been censored until the following day when they actually talked to the school administration and learned that these stories were objectionable to the principal. And at the time, this became a controversy, not just in the school, but in the community fairly quickly. And the principal was responding to public media about these stories. And among the things that he said were that he felt that these topics were just too sensitive for a high school newspaper, pregnancy and divorce. In fact, he said that the divorce was never an appropriate subject for a high school publication to be considered. So in any event, the principal censored, the students appealed that decision unsuccessfully, and they attempted to excuse me, I'm sorry, trying to get my screen back. And now I'm going to you, Mike. Sorry.
No, that's okay.
In any event, the students took the school to court in the fall of that year, 1983. And then what it ultimately ended up happening was they went to federal district court in St. Louis, where they lost in a fairly troubling decision, but one that wasn't really based on much legal rationale. They appealed. They won before the Federal Appeals Court in St. Louis, the 8th Circuit Court of Appeals, and then the school district asked the U.S. Supreme Court to hear the case, and were unsuccessful at that level, and as we know, and the reason why we're trying to cure it. So back to what the court actually did is, in the ruling, the court had the opportunity to reconsider the ruling of the Hazelwood, or the Tinker decision that had been decided in 1969, which opened up a very strong level of First Amendment protection, as we talked about earlier. The good news, I guess, from the Hazelwood ruling is that the court didn't reverse Tinker, they simply distinguished it. They said, we believe Tinker doesn't apply in the context of school-sponsored speech that hasn't been designated as a public forum. And what they did then was create a lesser standard, which we come to know as the Hazelwood standard, that says school officials can really engage in much more extensive censorship when they can show they have some educational justification. It's not an unlimited license to censor, but it's a much greater authority to censor than had been recognized under the Tinker rule.
It really changed everything. And you know, when you came in 1985, what was the SPLC's involvement at that time? Had the students at Hazelwood had they actually contacted, I guess, your predecessor, Mark Abrams?
They had, yes, and they were in touch. We were talking with their lawyers at that time, and we filed an amicus brief, a friend of the court brief, before the Federal Appeals Court, really not long after I got there. I started in May of 1985, and it seems to remember that we filed that brief in about August, maybe, of 1985, and then the appeals court heard the case that fall of 1985.
And they ruled for the students. I mean, they pretty much adopted your argument. So at the time, I'm guessing you thought maybe it was over. We'd won, right?
Exactly. I mean, you know, and the great thing about it is what the appeals court said was, this is a simple case. Could the school demonstrate material and substantial disruption or invasion of the rights of others would occur from this publication? And the short answer was no, they couldn't. They hadn't presented any evidence. And the school essentially admitted, no, we don't have evidence of that. What the school argued is that we shouldn't be obligated to meet that Tinker standard because this was school-sponsored, tied to the school curriculum, that we should have greater authority to censor it. And that was the grounds on which they requested Supreme Court review of the case and ultimately got that review.
And so I don't think anybody was expecting the Supreme Court to take it, but they did.
Yeah.
And so 30 years ago this month, they handed down their decision. Tell me, what was, I mean, at the time, I mean, there was no internet. So how did you hear about it?
Well, let me say one other thing. Yeah, you're right. Pre-internet, the world was a very different place. But why did the Supreme Court agree to hear the case? It's a fascinating question. And I really think that a big part of the responsibility for that lies in the hands of the National School Boards Association and the National Association of Secondary School Principals that filed briefs with the court, especially the School Boards Association, that essentially said the Eighth Circuit's decision in Hazelwood, despite the fact it was a direct application of Tinker, which other courts across the country had applied in much the same way, they said it will result in chaos in our schools. Inmates running the asylum is a phrase that was used at that time. I don't know in one of their briefs, but at least was discussed. And their concern is what I think persuaded the Supreme Court that, oh, somehow this was terribly, problematic, this Eighth Circuit ruling. So, but anyway, you know what, the Eighth Circuit or the Supreme Court decision, and back to your question, how did we find out about it? Well, you know, it was largely through phone calls. I mean, you know, we basically got a phone call from a reporter saying, who was at the Supreme Court saying, the Supreme Court handed down its decision, here's what it said. And we sent somebody down to the courthouse to get a copy of the opinion.
So what did you, I mean, and I want to bring Frank in just a second here, but what was your take and the general consensus of First Amendment attorneys when this case was handed down?
Well, I'll tell you, it was very quickly apparent this was going to be bad because it opened the door to a level of censorship that we had not experienced as in a context where it would have been considered legally permissible. You know, basically the court gave examples in its opinion of the kinds of censorship, things that might associate the school with anything other than neutrality on a matter of political controversy, for example, that were like, well, what couldn't fit within that description? You know, things that are ungrammatical or poorly written. The Hazelwood decision was really had the potential to open the floodgates. And it really wasn't until we saw the impact state laws could have in California and other places that we realized there was maybe a light at the end of the tunnel here.
Cool. Well, Frank, this is probably a good time to bring you in. You joined the SPLC in 2008, so the decision was 20 years old at the time. And the shock was gone, I guess, but the impact of Hazelwood was had definitely taken hold. How did a mature Hazelwood differ from the Hazelwood that Mark experienced 20 years before, or did it differ?
I think when you're talking about Supreme Court rulings in areas like civil rights and human rights, there's the actual wording of the decision, but there's also the larger cultural impact of it. There is a mentality and a climate impact of it. It's never just about the right to sit on a bus. It's never just about the right to sit at a lunch counter. It's always about bigger things, about what we value and what we respect and how we think people should be treated. And when you really read Hazelwood and you see where the court was placing its priorities in that opinion, they deviated very, very sharply from, there's an entire kind of a generational change in the Supreme Court between 1969, when the Tinker versus Des Moines ruling comes down, the one that was this kind of sweeping declaration of the importance of the First Amendment in schools, and then you fast forward 19 years to Hazelwood, different composition, different court, and no sweeping language at all about the importance of the values and the principles of freedom of expression. Instead, and Mark alluded to this, the overriding concern is protecting the school against the students. The idea is not that the Supreme Court exists and that the Constitution exists to protect vulnerable people against the government, but that it exists to protect the government against the vulnerable people. And so we're going to sacrifice the First Amendment rights of our students so that the public doesn't get confused that the school might somehow be responsible for a politically controversial editorial. So we're going to put the image of the school, the image and the reputation of the school, and the ability of the principal to get through the day without getting an irate phone call ahead of the free speech rights of our citizens. And that priority shift, I think, really created a cultural and a mentality shift, both among the people who run schools and, equally importantly, because I don't think we can ever let these people off the hooks, among their lawyers. School lawyers really have the ability either to be the conscience of the school or to be enablers. And unfortunately, a lot of them have become enablers. A lot of them have, as a constitutional lawyer, it is just nails on the chalkboard to me when I see that a school lawyer or one of these state school board associations or administrator associations has created what they call a model policy for the governance of journalism. And the model policy is language taken straight out of Hazelwood versus Kuhlmeyer. Well, if you just think about that for a minute, they're saying that Hazelwood, which is, after all, the floor, it's the lowest level of constitutional protection that you can possibly give people, right? The Supreme Court said anything less than this is unconstitutional. And from there, these school authorities, these experts in drafting school policy said, well, we're going to take the lowest level permissible and turn that into a model so that this is not 1 millimeter away from unconstitutional. It is the optimum for which you should shoot. And for the Supreme Court to give everybody this range of 0 all the way up to Tinker, and for everybody to default to 0, right? We don't do that in any other aspect of education, I hope, right? We don't do that where we say, what is the worst thing that we can do to kids and get away with that? What is the least that we can give them and get away with that? We don't go to the school lunch program and say, well, what is 1 calorie away from starvation? Alleged is 1 calorie from starvation. Give me an eyedropper and let's make sure that we apportion this nutrition in such a way that nobody gets 1 drop more nutrition than is absolutely necessary to meet the law. And that's what Hazelwood has done. Hazelwood has created this mentality that there's kind of an entitlement to censor. Yes. That it is a right to censor. You'll hear that over and over again, that people who should know better, who should understand the Constitution better, will say, well, the Supreme Court gave me a right to do this. I have a right to do this, as if you're taking something away from them if you restrict their censorship authority. Well, that's not how rights work. Rights protect us against the government, not the other way around. But Hazelwood really ushered in that mentality that somehow schools needed to be protected against their students, and it was a legitimate and constitutionally and Supreme Court validated use of their authority to silence people in order to protect reputation.
Yes. I thought when Mark was talking about the National School Board Association, some of their language coming out at the time talking about how this decision was good because it prevents the inmates from running the asylum. I mean, that's exactly what you're saying. And a lot of people don't know, but it's so interesting they said that. But the language, the actual framework for the Hazelwood decision came out of a prisoner speech case the year before. So it's not very far away from reality here.
Absolutely did. It was a cut and paste job. The year before, the Supreme Court had a prisoner First Amendment case and came up with the phrase "legitimate penological justification" was where they set the boundaries for censorship, and they literally just cut and pasted that justification right out of the prisons and said "legitimate pedagogical justification." And so they clearly tweaked it just enough to make it applicable to education. But I don't think the public, right? If you really explain this to the public, I don't think that the public thinks that's right. I don't think the public thinks that the right amount of freedom in schools is the same amount as in a maximum security prison. I don't think they think that's true, but that's what the Hazelwood decision has enabled people to default to.
Yeah, and Mark, maybe bring you back in here too. But I mean, we've had, it's 30 years. We've had what, 2+ generations of students, work their way all through through their 12 years plus of school under a Hazelwood regime. We have a president in the office, in the Oval Office right now, talking about how the press is the enemy of the people. I'd be interested in both your takes. I mean, does Hazelwood and kind of this culture that Frank described, does that kind of factor into where we are right now?
I think it does. I mean, in my mind, it's a reflection of the lack of value we place on the role of free expression and free press in our democracy. I mean, it's interesting because I think if you ask most scholars or historians, they would tell you it is probably one of the most distinguishing characteristics of our nation. Certainly, we were the original, protector of free expression and press freedom in the world. Yet, what we treat it with such disrespect in the environment where we're preparing the next generation of citizens.
Yeah. And Frank, I mean, go ahead. Yeah.
I think to that point, to me, the most toxic lasting impact of Hazelwood is this idea that it imparts to our students that criticizing and questioning the government makes you a bad citizen. I mean, that's really the message of Hazelwood, and it is the way that schools use that authority. They will claim that they need that authority for student safety or for to protect vulnerable students against doing things injurious to themselves and others. But we all know, and combined on this call, tens of thousands of phone calls, right, that we've answered from students. Never does a student call and say, I was trying to threaten violence against somebody and this didn't stop me and I'd like to get a lawyer, right? This never happens. Schools use that Hazelwood authority not to protect students, but to protect their own image and their own reputation. The idea that the government gets to tell citizens when it is okay to criticize them and not to criticize them is such a civically toxic idea. And it's, I don't shrink from saying it is an un-American idea. It is an un-American idea. And we have all this hand-wringing going on around the country right now about, surveys show this eroding First Amendment respect on college campuses, and people don't value the First Amendment like they did a generation ago. Well, guess what? They've watched the First Amendment and the principles that it stands for be disregarded, ignored in their entire educational lives before they get to college. And so why would anybody believe that the First Amendment has any value? Why would they believe that it has any force? They have watched the government wipe their feet on the First Amendment for 12 years.
Yeah, and it's not done. I mean, you mentioned that, they up until college, but Hazelwood goes into college these days. I mean, that's one of the things we've seen.
Mike, let me offer one other thought too about that, is that Hazelwood also, I think, represents an amazingly significant failure by the Supreme Court in clarifying the law. If you accept that one of the roles of the Supreme Court is to settle the law, not to make it more unclear, I think it's very obvious it did just the opposite with the Hazelwood ruling. More school administrators and students and advisors and parents are confused about what their students' First Amendment rights are today than they were before the Hazelwood decision was handed down. After 30 years, we are still struggling to figure out exactly what the Hazelwood decision means.
I mean, you're with me, I'm sure, and just I've had 30 years nearly of experience trying to explain to a high school student and to teachers, what is a public forum and all that kind of stuff. It's crazy. You're right. It totally muddied the waters in terms of just being able to explain the law.
You mentioned, Mike, that Hazelwood has made its way onto college campuses. I think a lot of people think of this Hazelwood level of control as being a K through 12 problem, but increasingly it's everybody's problem. It's a college problem too. There have been 2 instances on which the federal appeals courts have been asked specifically, does Hazelwood apply to journalism and to news outlets at the college level? And those decisions are split. There's one from the 7th Circuit up in Illinois indicating that the answer may be yes. There's one from the 6th Circuit in Tennessee indicating that the answer is no, but we have no real clarity, and the Supreme Court has never addressed it. But outside of the newsroom, it's now becoming widely accepted that Hazelwood is the default standard for all speech on all levels of education.
Good point.
Using some kind of a platform that is provided by the institution, right? That's the dividing line. There's tinker speech, which still is a good law and it still exists, right? Tinker speech, when you're using your own communicative vehicle, the words coming out of your mouth or the apparel that you wear. But when you're using a communicative vehicle that is in some way provided by the school or affiliated with the school, then you get the diminished level of First Amendment protection, which functionally has turned out to be almost zero, right? Almost no one ever wins that case once their speech is determined to be governed by Hazelwood rather than Tinker. And we're seeing circuit after circuit beneath the Supreme Court, in the absence of the Supreme Court speaking, saying, well, we regard Hazelwood as the default standard for all college student speech. And so if you're that college student who speaks out in the context of a class or an academic exercise of any kind about something that you think is wrong at your institution, there's every likelihood that the courts are going to say you have no First Amendment protection either.
Yeah, it is. It's time that we kind of wake up to some of this stuff.
And there's hope. There's hope. Yes.
Okay, that's what I was going to ask.
Talk about new voices.
we have about 2 or 3 minutes left, so let's talk about the hope. Yeah, where do we go from here, Mark?
Well, I would defer to Frank on this. As I vividly remember the day of the Supreme Court decision, learning about censorship at a high school in California and learning that they were able to overcome it through a law that existed in California that had been largely ignored up till that point because it was seen as just a duplication of rights embodied in the First Amendment as defined by Tinker. But when the Supreme Court lowered that First Amendment hurdle in Hazelwood, suddenly this California law gave a remedy for students there who found themselves experiencing censorship. And it opened the door to the beginning of an effort to get state laws passed that compensated through state law for the reduction in free expression protection that the Supreme Court caused as a result of the Hazelwood ruling. And, in the course of the next few years, we had about 6 states pass laws. Then there was a long dry period. And in the 2000s, it started again. And Frank, it was instrumental in really pushing this effort forward again.
Well, let me share 2 resources real quickly, Mike. You gave a shout out to the splc.org website, but I want to share with folks the 2 other websites. The activevoice.org. The activevoice.org has research on it demonstrating vividly what the SPLC's anecdotal experience has already shown, which is that censorship is a pervasive experience in the lives of students, that it differentially affects young women, that it affects young women to a greatly disproportionate rate, and that it stops people from talking about important issues of social and political concern. The activevoice.org website has this research on it conducted by professors from the University of Kansas surveying high school journalists about their censorship experience. And I think, honestly, because of everything that we are seeing out there right now in our culture about the Me Too movement, about students at the high school level mobilizing against sex discriminatory dress codes, that we're at a moment where we might possibly be able to tap into some more powerful cultural forces to get people finally mobilized to turn the corner on Hazelwood and to pass these reasonable and balanced state laws. And this is the other website that I wanted to share, New Voices US. The newvoicesus.com website has on it resources that advocates can use to try to pass laws in their states. Mark mentioned that in 2007, the progress kind of ground to a halt with the passage of the Oregon law. But then in 2015, we were reinvigorated by the work of great advocates like Steve Listopad in North Dakota, who deserves a lot of credit for lighting a fire under the movement to cure Hazelwood. And you'll see on the New Voices US website that we now have 13 states with these wonderful laws and 7 bills pending all around the country, from Washington State to New York, and a real shot at passing enough laws that we can get close to. If we swept the table this year, I think mathematically half of the K-12 students in America would have protection against Hazelwood. A great goal for us to shoot for.
Very cool. Very cool. Well, unfortunately, guys, we are out of time. But I want to thank both of you. This has been really, really wonderful. Mark Goodman and Frank Lamani, thank you for joining us on our day of action for Hazelwood. I encourage all of you to join us throughout the rest of the day. We have, like I said, speakers on the top of every hour. We have Mary Beth Tinker and John Tinker, and I'll actually be talking to Kathy Kohlmeyer of Kohlmeyer versus Hazelwood fame a little bit later this evening. So, and again, if you have any other questions about your rights and what we've been talking about today, visit our website at www.splc.org. And I think that's it. I don't know if I'm going back to Danielle or not, but thank you guys, and thanks everybody for joining us.